What artistic photography I can see it. Bigger, wonder. Yeah. Good deal. Huh? Yeah. What? You matter? You. Like, or to play a pilot of the time, not on record. Maybe for. Yesterday we have five. Okay. Okay. But the other side and I think. Not to be cheaper, but we'd like to put pilot product. What is the starter? The taste of the some exchange that I've not really got into it, but myself. The instructor has not got into it. But there's something that the department is quite interested that we find very interesting. I've not got it. What did you find? Give me item three. What is the matter about? What is the tender matter? You believe? Yes. You have not read the fail. No, I have to. Basically, that he had submitted the hard copy after the last. After the last. Yes. He had done it by way of net banking. But good for the petitioner. Our time. What is that? You'll be filing with the first of the day. Then why do you need 1 week? You're not making sense. You said you'll be filing it within the course of the day. So it means today. Yes. Let it stop of record by Mr. And we are appearing for the PWD submit that affidavit deposited will be filed during the course of the. Accordingly, this is matter executed. What is that? What case? What that water? Okay. Huh? How the? This thing. Come down to the listing. Pending matter. Pending. Go to the registry. The Anjana. And then counted for the particular place that it may be allowed to withdraw the return. Where is the house? This particular business has withdrawn. That's all. Huh? Okay, with liberty, huh? With liberty. I is also, here the other passes have been, dispose of a party. But they are making payments to other others. Huh? They are making payments to others. Okay. But not to you. Not to me. Okay, you take steps within 3 days. 4 weeks. Put one and two. Huh? Put one and two. One and two also same. Already there. Already. 4 weeks. Yes, what are you asking for? Lots of green subsidy, lots of huh? Subsidy at the why have you filed it now only? Lots of following up with the correspondence, but there's no movement. Initiative for the board, they have come up for that they have follow document. Internally, they have asked for the document. Maybe even by the tender. But still, what is the period for this insurance? For which period? Buy is for period logic 20 April 2009 to 19 April. In all the cases, in all the periods. Different periods. But it is for which year? For 2009 to 2010 or what? 9-10. All of them? Yeah. Case number 4 is for 9-10. That is 20 April 2009, 19 April 2010. And for others, for all the others, for others, lordship, item number 5 is 7. 2006, 2007. I write it down, huh? For 2000, for item 4, it is 2009, that is not required. For the next, it is 2006, 7. Then, item number 6 is 5, 6. Huh? 2005, 2005, 2006. Yes. And then item number 12, 2010, 7. Item number 12 is 2010, 2010, 2011, then. And item number 14, 2007, 2008. 2007, 2008, item 14. Yes. Okay. So you are Mr. Dr. A2. Huh? Dr. A2. What doctor are you with? What doctor? I that doctor. There's a lot of delay in that. That will keep it open, maintainable to the request. Who appears for the 2, 3, and 4? Huh? K. Kalita. On behalf of K. Kalita. For 2, 3, and 4. Who appears for 1? What is the name? R. Paikya. On behalf of K. Mehdi. For point number 1. That's all. Anybody else? 5. Who is for 5? Petitioner takes step. Already stuff. No. We will see this. So, yeah, yes, all for 5 weeks. We can 5 weeks. 5 weeks, no? Without it. So, only that 2006, 7, that will. Item is 4, 5, 6, 12, and 14. Huh? No. Uh, this item 4, you write, tag this matter along with WPC 2025 of 2025. Huh? Then in 5, you don't have to write anything. In 6, 12, and 14, you write the same. Same. Then one of the chances will follow that weight 40 on a very small amount. It takes to pay by the fulfill both and the company issue reached by us with was that whether they have no, but the reference was whether the retrenchment was justified. That is where the other traffic power. It's a counter allegation from both retrenchment from one and voluntary resignation for retirement for the other. So therefore, one to stand. Now, how that first issue, the framing being wrong, the culmination is wrong, and at paragraph 33 and 34 for a moment, how the tribunal and page that would be page 49. 49 of the order, 49. Yeah. Which directly if I need 32. Very. Sri Subir Kumar Singh, NW2, in his evidence also stated that the management did not terminate the workmen. They had voluntarily resigned from their service to the management issued notices against them, but they refused to receive the same order. Stated verbally to the management that it did not want to continue the job. Safe.
to that extent the management is true. But before taking quality example, any one of them is to inform the management or with an application or letter so that the date and time is calculated for taking delivery. Now, what I am on basically is the factum of a stamp of voluntary resignation being accepted, but the procedure being altered with different courts. But the issue is wrong. When the court, the tribunal proceeds on the factum of retrenchment, then I should.
Why didn't you challenge the reference? The issue that had been set by the government.
Whether the management of Pakamya about concept application and justifying retrenchment of 8 numbers of employees is mentioned. To that, we lay our things that even we are expecting the gratuity and we're ready to pay it.
Why didn't you challenge the issue frame?
Or the so far so to be travel down.
Huh?
So far travel down. But our stand, our evidence, everything being accepted by the tribunal, and thereafter on technicalities being
Accepted to the effect that they had voluntarily resigned.
if that be so.
Was no did the tribunal accept that they had voluntarily resigned?
Yes, yes. 33 acceptance. Paragraph page 33 at page paragraph 33 at page 49. If I concurrently read 32 and 33, say to that extent the
It says they failed to prove.
absolutely. Say to that extent the management is true, but we fail to prove. What I am on is that when the learned time is proceeding on retrenchment and then parallelly appreciating the voluntary part and then accepting it, but negating on the count of procedure niceties, my lord, the learned time Thank you. So therefore, my lord, as the counter pleas were there, and the issue being framed on one side, the appreciation to that effect, my lord, is visual. And therefore, I pray for Lucas, my lord. And we are paying gratuity. They are accepting the gratuity of 50,000 per head we have paid, I'm told. And 7-8 lakhs more, or we could continue to pay. But they are silently being considered. They're accepting the use on the one part and also the benefit of paying on the other part. They fail to, the learned tribunal says both parties fail, but the issue was not there. If there was no stay, they would continue. Then the entire matter becomes interrupted. Unless
Let them first come with.
so they are on table.
Who are with them?
They are on table. No, we have served it. I believe we have served it. Unless we serve, we could never be discussed. I'm told.
Well, what can I
Like it. I get it. Again, we again hand over it. Addition.
Okay, mister? So what about you? Pokaler, you have found one? Three Pokaler. Mr. This day, Mr. SD. Appears for the caveat appears for response number 2. And submit that he has not been given a copy of the writ petition. Mr. S. Banik has furnished a copy of the writ petition to Mr. SD. Here in the court. This then do we call for the record? Oh, call for the okay. When do we release this matter?
As early as possible.
When?
Up to date. As early as possible. Hearing.
Then this matter after 4 weeks? For the report?
The reports are after the next meeting. When the reports
Release the matter after 4 weeks. On the next date, the issue of the prayer for the interim order shall be published. He has not been given a copy of the order. By surprise.
if permitted, it's all you do. After the matter.
Why?
Because the matter should not have been listed otherwise. But putting everyone to tell him because it should not have been listed. He's not getting a copy.
Let's see. Let it go. That may be there.
So even before
There is no KVA though. There's no KVA. It's not displayed. The KVA is not displayed. Huh? You
They
see,
must have
no,
a
in
KVA
the
from-
cost list, there's no KVA. Then don't say KVA. Receivable by the government. There's no KVA. There's no KVA. There's no KVA. You were the one who said.
we had
Okay,
a
right.
order.
Already done. So perhaps everything, right? Mr. President, accept notice on your fund number. Call fund number. This is matter. When?
After taking,
No, he wants to stay.
then this month, except 25 and 6. 25.
24. Matter 24. On which date the paper interim order shall be considered. Well, already there. Did that fella. There's nothing. Item? Eight. Okay, Mr. BP Borajan, okay. So who is accepting notice on behalf of respondent?
I'm, I'm accepting on behalf of respondent number 4.
What is your name?
A.N. Sharma. Perfect.
A.M. Sharma. For, respond number 4. Then what else? One, three, and five. Who are you? E. Bora. And then who is for respondent number 2?
Please, I think
R.M. Barwa. R.M. Buyar. Then Barwa. Very good. How to spell the Barwa? No, Barwa. Barwa. B.O. Right. Okay. After 4 weeks, you file your affidavit. Yes, it's already done. Like it. Yes, madam. For payment of contract. Huh? Chief engineer is not a party. Right there, yes, number 5. Okay, right. Which? J? Oh, S.I. Keto. Leonard, you're from where? Which tribe? Huh? Leonard counsel for the petitioner. That means that the contractual dues of the petitioners amounting to rupees 14,960,62 for installation of bio-type toilets has not been given by the respondent. Ms. M. Khalid, because if you notice it, there was Ms. M. Khalid accept notice on behalf of for all the respondents except for respondent number 4, who is represented by Ms. R.M. Barrow. Huh? Similar. Amount?
Amount of 35,000.
9,35,235. Out here it will be again by a five.
Respondent number 3.
Huh?
Respondent number 3.
Okay, out here, this M. Kalita, actually notice on their policy number
5.
125. Mr. G. Bokharel, actually notice on their policy number 3. While Ms. R.M. Barwa, actually notice on their policy number.
Okay.
Sorry, what's your name? Ms. G. Talukdar, learned counsel for the petitioner. Petitioner submits that the bill for the printing works done by the petitioner amounting to rupees 31,10,239 has not been paid. If you notice, returnable is moving.
But they will not match work order. Work order, and in fact, these are very good because the lots of problems for the team. And the three, there are three cities networks. The providers are different. Then the work order providers are different. And I have page number 3 of the reason.
Page number 3.
Page number 3. MS Modern Printers, MS Upset India.
What page number 3? It starts from page number 3. Oh, yeah. MS Modern Offset.
And again, MS Modern Offset. There are three providers having two different providers. In fact, the first one, they have not mentioned who is the provider, and they have no work orders. There will be different work orders for each of them, and separate for the next year.
Sure, what have I said? No, before that. Ms. So stop this current. No, but you also submits that the matter may be adjourned. For what? For when? Next week. Adjourned. Why? Where is your senior? Huh?
8:30.
Where is he?
8:30.
Where is he?
Different. 34.
For Eid. When is Eid? Tomorrow. Okay. He plays for adjournment on behalf of a senior Mr. H.R. Chowdhury. Next, Mr. A. Ali.
Yeah.
A.I. Ali. 11th Council for
Response number 2 and 3.
report number 2 and 3 submits that there is no specific, there is no particulars given with regard to petition number 1. And all the petitioners, all the 3 petitioners are different persons, Stop. No work orders have been annexed in respect of any of the petitioners, correct?
Annexer 3, they have mentioned that there is a work order, but in the Annexer 3, that they have annexed, there is no work order. Only
Not
one work
annexed,
order.
have not annexed any work order despite having stated in para 5
There are 5.
that work order dated 1/4/2009 had been issued.
Only one report is there, case number Annexer 11, page 46. It is regarded to respondent number, petition number 1.
So further,
Here,
the work order mentioned in
page number 46.
page number 46,
Annexer.
bracket annexure 11, pertains to the petitioner number 3 only. Accordingly, submit that the writ petition is not only benefit of particular, but the cause of action of the petitioners would be different. Accordingly, submit that the writ petition should be good. In view of the prayer made by the petitioner's counsel, list the matter on Monday. No. What is this writ petition? Yes, madam. Any idea?
Since as regards to forest royalty, forest royalty,
How does it affect the petition?
the form was not granted, permission was not given by the authorities to, for construction. Just, Lordship, you said, the petition has been disposed of on earlier date, by the name of Amar Dekka, WTC 4068 of 2024.
The same, this writ petition.
Lordship, similar matter.
Well, has it been mentioned? Well, this is a covered matter. 6225. 6425 or 24. So this order notification that is challenging, that has already been set aside. Already been set aside in another writ petition. Have you got the order? Forest royalty matter. Number of cases had been disposed of. Huh? Which one? This 2223. So this has been set aside anyway. So, okay, right. No one appears for the petition also. The prayer of the writ petitioner is for setting aside the impugned communication number PM post of 174 double 6 slash 183 dated 2/3/2026 issued by the Joint Secretary to the Government of the State from a Mines and Minerals Department. Next paragraph. The communication dated 2/3/23 that has been put to challenge in the present case has already been set aside. In the judgment and order dated 24/9/2024 passed in WPC 4085 of 2024, wherein it has been held in para 19 as follows. Para 19. In view of the above, this court finds that the present writ petition find that there is no reason to keep this writ petition pending any law. The present writ petition is accordingly closed, keeping in view the fact that the prayer of the petitioner has already been answered in the judgment in para 19 of the judgment and order dated 24/9/2024, passed in WPC 4085/24. Okay, I will put the name.
Appearing on top of the neck or two.
What? It's Kalita Farm. On with. Mr. Bokalal, are you there? You're not there, okay.
Highly agree.
What kind of petition?
I have a limited for consideration of my representation. But after the representation has been filed, there has been inspection,
There has been inspection.
and both has also been installed. I have stated my, and I stated.
It has been installed. Transformer installed.
Not,
What has been installed?
pole.
Pole.
I have given the photograph also. So,
So, what is to be done?
but transformer has not been. It was this is slightly different, but about perhaps taking electricity for the after. Not check, not affecting. If we come back to this.
Or take a decision on the representation. What is the, I think, we cannot force you to do something. You cannot demand a transformer unless you have paid for it,
I have approached them, filed the representative now.
Are you willing to pay for it? Are you willing to pay for a transformer?
If they, if on the representation, they ask,
In your representation, have you said that you are willing to pay for a transformer? No. And you see, it depends. So, transformers are a small thing. They are small transformers, they are big transformers. If they provide you electricity, that's enough. Whether the electricity consumption or the distance from the nearest supply point is very far, then you might need a transformer.
I have stated that activity.
Everyone is in necessity of electricity. You're not the only one. Everyone in the world needs electricity. I am asking you, you want a transformer. Are you willing to pay for a transformer? You take instructions, then you come back. You cannot ask something which you just without giving reasons as to why a transformer is needed. Is there a transformer requirement in your place?
Yes, Your Worship.
Why? Give me a reason why.
Because
What is the load? What is the load that what is the electricity load that is required? Look, you're going to do some homework. You cannot just go and say, I want that big cake
regarding the payment.
and I want to eat it because it looks very beautiful. No, that's not the issue. Why? You have to give justification. You see, transformers are usually used if there's a heavy load or if the distance is so huge from the point of supply.
I have stated that there are 150 categories of food. And there are nursing home and hospitals to also there. And one mental retarded person halfway home.
They take a decision on that application. Rest of the thing. What? Is it all right? Huh?
I'll leave it to doctor. Otherwise, I can come back with instructions on Wednesday. Whether or not we can get out. If there is a clear issue.
Okay. Okay, so it's done.
Yeah.
Here,
Yeah.
let's ask you for the petition. Submit. That the petitioner has requested for installation of a transformer at Site 4, Part 1, Qatar district. Where the Qatar district, why? And in this regard, a representation is also a representation dated 17/5/25 has also been submitted. 17/5 and today is not even a month. What is this?
After that, you know, I have because they have inspected the safe use of the funds. So the inspection will happen subsequent to us getting them an estimate. But this is the amount.
You cannot figure this.
Of this representation is by the NGO. Of the facility.
Petitioner is not the
Coordinator of the NGO.
oh, who are you? Who are you? Who are you? Have you got? Are you the project coordinator?
Yes, sir.
Huh?
Yes, sir.
This is Image Barbuya.
Yes, sir. I have given that.
Achha, you are Image Barbuya. Mr. Mr. Peter. P. Chaudhary appears for the APTCL. Submit that he has got no permit to make assessment. How he will obtain instructions by witness. This is a matter of witness. Mr. A. Dekal and counsel for the petition submit that the vehicle hire charges amounting to 71,25,976 has not been paid. If you notice, Mr. E. Bokaliel accepts notice on behalf of all the respondents. This is the matter of for which to enable the respondents to file their affidavit. Obliged. What should be done? Like kindly. Mr. Watch the parcel of a couple of times. What is your case? My case is that there was a notified tender which says that the tender period would be coming. So you're challenging the award of the tender to the respondent number 5. Correct. On the ground of what? On what ground? On the ground that and also the tender because there was process. Mr. Counsel, you took part in the tender process. You cannot turn around now and challenge that when it has not been provided. The provision there is that there has to be a press and in certain cases, especially when there is the whole bid amount has not been deposited. Required as per the tender. Process in writing. They have deposited half the amount, it's less than what I paid. Clause. Which clause? Clause 7, my lord. Page number 17. So that this is your 7 is the only thing. That he has to submit the bid amount, but he has not submitted the bid amount. I'm allowed to deposit half the amount. So it may be offered to the next highest tender or retender. So are you the next highest tender? I'm fixed place. Then but where's the question of retender? That depends upon the discretion of the authority. But we have to take a call because they're saying you deposit the full amount. So where is the representation to them? For them to take a call, have you informed them that this has happened? They have already awarded the tender. It's the council. Half the amount. Where is your representation to the authorities that this clause 7 has been violated and it should be retendered? You cannot come directly to this. You final representation to them. This is a court of the last resort, and you come without even filing a representation to them. You come here. Okay. You file a representation to them. Give them some time to think about it. If they don't do it, then you come here. Tender period is, my lord, merely 7 months, 8 months. So what? Give them at least a week's time. Give them 2 days time, 3 days time, but you have to go to them first. I've actually gone, my lord. There is no document. Please give a letter. I do not know whether you have gone. Give a letter to them. The figures is not published, my lord. Whatever it is, how you know that it has been given to him? That award is there. What is that? Now you please write to them. Say that though you have awarded this contract for collection of the entry tax to the respondent number 5, the same should be retendered, or if the contract should be awarded to the next highest tenderer in terms of clause 7 due to the respondent number 5 not submitting the entire bid amount. You cannot come directly to the cannot. I'm dismissing it straight away. How do we withdraw and go there? That's the thing. Ultimately, the people will file a representation first. Which yes, sir. Huh? Yes, sir. Let's see. That's process for the petition. Something that it is to withdraw the petition. With liberty to first approach the responding authority with regards to his file their particular thing. and thereafter to file with petition affect with the representation in the 5 years time. Other person so, we gonna buy an appeal form, yeah, but appears on behalf of Mr. R.M. Das, direct counsel for the respondent number three. 1, 2, 3. What is the prayer of the petition founded in the which petition? Which liberty? Yes, no work order issued to him. That is the case. Fine. He is L1. He says that no work order issued to him. Huh? Correct, but he wants to work order. When were you selected? 24? 24, 3, 2025. So you're going to take a decision, cost of everything is going up. Supposing I want to buy bread today. And I have to take permission from you to buy bread. Supposing you give me permission after 5 years, cost of bread will then will gone up by 1 rupee, and so he's worried about that. You appeal the structures as to why are you going to continue with the contract or not? That's all. Huh? 25, and my law electric I am L1. When were you made L1? When was the financial bid open? When was the technical bid open? I could not mention, but people are. Sorry. Then there is no proof that you are L1. If there is no opening of bid, have you written a letter to them as to whether you are L1 or not? How do you know you are L1? But they are given certificate. Where? Show me. Page 97. 97. 97. Yes. The Canada typing the Canada for which I applied for, and finally for the name name of the visa, serial number visa, 7641 is the correct visa, and use serial number 1. Visa ID is the amount pension, last and this year, and this year, L for I am. Which date is this? You know, somebody has not from the visa, the future in the contract. L1. Right. Mr. Here again, learned counsel for the petition. Submit that he has participated in the 27 to 25 months. Yeah, 290, show me the NIT. Show me the NIT. 27 2 is at page 12. Yeah. Where is 27 3? Page 15. And 17 is the gender details. It's the council for which Exactly, are you talking about? Are you for 27-225 or 27-325? It could have been last two years, 27-325. Not 27-2. All of them similar, same, not like the last quarter. 27-325. Particulars of the tender given page 17. One of the tender and the petition was declared L1. Other stuff. However, no work order has been issued to the fifth. The PSPO shall proceed to practice with regard to this. This is the matter. Absolutely. Only one friend, my friend, what even order is passed, that is subject to the. Sorry, only subject to it. The other they lost it, I have a lot, sorry, other kids, other kids. Notice the issue, you don't code me, why should I issue notice? Something in a minute, they reject my tender. If they reject, then you file a fact petition. That's a fact for the matter. I filed that, but enough. Don't do it. Yes. Yes. I leave it to your lordship, my daughter. My lord, only the thing that my your lordship now, my daughter, take the my lord the affidavit filed by the respondent. Just to bring this to your lordship. Every night, my lord, has your lordship pleases, my lord. Yes, the application 2, my lord, para 2. Page 2, paragraph 4A. You're in petition. Yeah, I'm the petition. But in my affidavit opposition filed by the. Which page? Page 2. There's no page 2, there's page 21, 22, oh, sorry, 20, 50, what? Oh, running, now it is running one. For the internal page 2, my. Now it's computer age, Mr. Council. The polo card is gone. Yeah. Everything is what now. Yes, my. Now it is correctly page in it. Internal page 3, my. So 2. Affidavit in opposition of the response. Internal page 2, my. Para 4A. Yes, 4A. Yeah, my lord, 4A, your lordship, last 5 lines. Yes. Last 4 lines. Payment against work done. 4 line, my lord, last 4 lines. Of para 4A. Payment against work done has been made to the contractor. Rupees 10,90,000 so after necessary deduction from the gross work done value of 14 lakh. So here in this para, this contract, he has done complete work. The petitioner has done complete work and also certificate of completion also given by the contract. Even though here, which contract work? Yes, there is contract work that is given by the. What is the number of the contract work? Contract letter number so in the middle, my lord. What is the contract agreement number? I want to know that. Contract agreement. Yes, that is page 23 to 26. 2376. Internal page. Huh? Internal page 23 to 76. This is the contract documents. No, you see, you come to See, there is, you come to page, you come to page three, page two,
Yeah,
para 4A.
yeah,
The petitioner was awarded with 5%. Okay, contract agreement number CBR 24 TF, so for supply.
yeah.
Then, so, that is one contract. Then contract number,
He is another contract,
B is another contract.
another contract. So,
Correct.
yes, sir. In
So-
contract A, my lord, he has done complete work.
You can see the contract was 06.
Yes, my. He has done the complete work. Your lordship will find the repetition and another two, the certificate, completion certificate.
Amount to be, no amount has to be recovered from the contractor.
But why there's a deduction again? Yes, deduction. 14 lakh something and payment that will make 10 lakh. And no,
That we have to, state. Wait, I don't remember where.
A, मतलब 4A. There are 4A.
That's the picture. You come to the additional affidavit filed by the respondent number 1.
Additional affidavit, whether it is maintainable also not, there is the question of maintainability of also. Neither he is authorized. He has to be authorized by the respondent. Nowhere the authorization is there.
That's only going to delay the matter.
No, I am not delaying, madam.
That's what
Or your lordship, that arbitration is there, it may be sent to the arbitrator. Arbitration clause is there.
No, we can say that. I will say that since the arbitration clause, that you avail of the arbitration. clause,
Yes, madam. That will also my advice, madam.
Because it has,
Some disputed things are there.
correct.
You may go to the arbitrator.
There are disputed questions of them. I
Yes,
think.
yes, madam. It's your pleasure who have come up.
I want to do because
Yes, yes, ma'am,
that
yes,
is
ma'am,
the
yes.
problem with writ petition.
Yes,
We
madam.
cannot
I,
decide disputed
your
question.
lordship, that's why when I submit as your.
Heard Mr. B. Sinha, learned counsel for the petitioner, and Ms. B. Sharma, learned CGC for all the response. Huh? Then you take the last order, last order. Para 4. The contents of the affidavit in a position and the additional affidavit in a position filed by the respondent clearly goes to show that there are disputed questions of fact. And as such, the same would require the parties to go into, would require the parties to go into
And that is the
various
51 arbitration clause is there.
disputed questions of fact relied upon by the party. Next paragraph. As where P,
Page 263. In the 263 of affidavit opposition. 267. 267 of affidavit.
and there is a arbitration clause in the contract agreement,
Yes.
executed by the party, wherein all disputes are to be, can be resolved of this court. Because the view that is petition to the avail of the arbitration clause for redressal of its fee. View of the above. In view of there being an authentication alternative remedy available, the present interpretation closed, is closed. With, with liberty being given to the petitioner to avail the arbitration clause, provided this contract agreement signed between them. Correct?
Fine.
Is there, what time? There is no limitation. Limitation starts only from the date the notice is issued. Yeah.
Prospect that we have taken, prospect that we
He
have.
wants the money only. It's only with regard to money, nothing else. He doesn't want to do the contract. Your case is that there is a risk and cost clause which has been availed of and he might be able to justify the profit. Only issue to justify the party arbitration, not by. Obliged. I know. It's, no one appears. What to do? We give one more chance. No one appears for the petition on first. No one has appeared for the petition on the last date of. The matter pertains to cancellation of the petitioner's arm license and the challenge to the state. The interest of justice, the matter. Yes. Let him. So it has been given to you.
That was the footwear.
Correct. As per this letter, 4 lakh something has already been, 4,75,355 has already been paid to the petitioner. By FOC number so and so, dated 12/1/2022, copy and so. It has already been provided. Yes, so the remaining amount is 12,15,000 pesos. That has now been paid. That's also been paid. That's the end of the matter.
No, let me check. Let me check. Well, they have sanctioned my law, total amount is 12,09,51.
Correct. Because the earlier amount of 4 lakh has been given in 22.
Liability, 17 lakh.
Correct.
They are equity.
Correct.
The rest of the amount.
Have you given this letter? Copy. Let him read it.
I'll find it. That rest of the amount they have not counted, they have not paid it, find out.
Mr. Counsel, this is what they have said.
So that's kind of fine. But as per their own evidence, they have admitted 17 lakh are actual final. Previously, it was 18 lakh, then they 17 lakh.
They can take up after
You know, they read the matter, they are
audit verification matter.
Huh?
After audit verification amount is developed, it's important. And other party, not that amount of people. If,
Maybe your client is not paying you.
Lordship can see their
Is
evidence.
keeping this information with him.
So I'm not, this epidemic is clear by law. Because Lordship sees the epidemic paragraph respondent number 4. Para 13 may be seen now. Para 13. Previously, we claimed 29 lakh, they have admitted 18 lakh, then subsequently they have admitted 17 lakh. Para 13 lakh.
Yes.
That they are to first statement, legal paragraph, go by, try to get the later on, by executive 45, that the admitted liability is to like 55 and not 55.
And thereafter they give this letter. Now what can I do?
So they have to pay the entire admitted liability of the.
You see, Mr. Kauser, out of this 17 lakh 16,075, they have categorically stated that out of which, they said out of which, out of the 17 lakh 16,070, out of which an amount of rupees 4 lakh is there. So they have said that this is a question of fact. You're going to dispute that.
I don't know what question is that something like that admitted. Correct? But they have not paid the entire amount, right? They've confessed.
Look, they have said out of which an amount of rupees, out of the 17 lakh 16,075, an amount of rupees 4 lakh 70 has already been paid to the petitioner. Right, FOC number says so dated copy enclosed. So this is here. So this 14 lakh, 4 lakh has already been paid. So the 17 lakh becomes 12 lakh now. Right. So this 12 lakh has now been disbursed to the petitioner. They said that. What remains? End of the matter.
Like, I don't know whether my client is thinking that.
Mr. Counsel, I do not know whether your client is telling you the correct information or whether he's telling the correct information. I'm going to close it. There's nothing else. You want to dispute this, you go to the other. Right.
Regarding the non-payment, it is the norm. You have to make it that they verify it.
Oh, no. Nothing to verify. Nothing to verify. If you are of the view that this is not the correct amount, you go into civil. No pain. What can I do? Why should I find your balance for it? This is there or something and not for the petition. So this along with this, then can give 5,000 for the response number one. It's the, we can appeal for response number. The petitioner, by way of the petition, has been a directive to be issued to the respondent to pay rupees 29,56,650 towards the contractual bill, contractual fees for having executed various works. Para 4, no, para 4, page 7, it started there, take it down. Next. The affidavit, the position filed by the respondent number is to be effective. Subsequent to the submission of paragraph coming to the Indian government of the state. What happened? While office memo dated 20/03/20. And amount of rupees 4,70,537. Again, work order number KP bracket R slash Q slash COL slash Roman 2 slash N slash 2006 dated 20. Dated 20/06/2006 had already been paid to the petition on 7/2/2022. While bill number 076 0786. Okay, sir. Let's go there. That's fine. Thank you. And what am I saying? No, no, submit that. It's, in terms of para 13 of the affidavit deposition filed by the respondent on the phone. The admitted liability of the respondent was rupees 17,16,07. And the sanction of an amount of rupees 44,70,535 had already been accorded, and the same had already been paid to the petitioner. As such, there was only the remaining balance of rupees 12,45,540 that was payable to the petitioner. Mr. Mr. M. Chettiar has submitted letter number, letter dash memo number S dash Roman 6 dash Kamrup dash MISC bill dash 2019 dash 20 no, no, dash 20 dash 121 2019 dash 20 dash 1 dated 3/6/2020 issued by the Assistant Inspector General of Police, Bracket Administration, Thomas Hassan Wati, addressed to the present council, which states that, huh, then right, the letter dated letter dated, the letter dated 3/6/2025 issued by the AIG Administration Wati is made a part of the and its enclosure are made a part of the record and marked as an corrective. A perusal of the state is to the effect that out of the admitted amount of rupees, admitted outstanding amount of rupees 17,16,07, an amount of rupees 4,70,535 has been paid to the petitioner on 12/1/2020. The remaining 12,15, out of the remaining 12,45,50, it was found that the actual amount in respect of the remaining amount of rupees 12,45,5%, an amount of 12,15,931 has been sanctioned after audit verification. And the said amount has already been disbursed to the petitioner. Next one. In view of the above, letter dated 2025, and the environment made in affidavit filed by the respondent. It was found that the admitted views of the petitioner have been paid by the respondent. Even the petitioner of the view that the petitioner has not been paid in view of the petitioner. Even even the petitioner may approach that even if turned down, then it is the foreign. Ah. Logic, here we have received the lots of which line with the honorable authority. What is language? Lots of on the officers, lots of I not be able to, but it's 100% logic. They ask for the process. We had received the proposed logic. It's not just regarding the petitioner. It's logic all the CF proposal that has been received. That was posted. They're all awaiting. The city to extent of we have received a proposal on 20th of May. Sometime before the weekend. Must be quite a predicament to think of what excuse to tell the court. Third project views are making us on the prayer of Mr. S. Kaliha. H. Kaliha, the Council for the Finance Department to fix 2 weeks time to obtain the latest status report. This is the matter. Right. And technical big word about if they don't have an account. But we have to have two big jobs. Director of Cuba. Pay? Pay second. Director of Cuba. Ah. Ah. In one out of one. Okay, this has to be changed. That is one. One has to be changed. No, has no reason to have one of them. Page 25. Page 25. That's the yes. Yes. Other which they can see here.
only this of technical information code. I have submitted the representation of my code to the immediate. They haven't got conflict here. And they have a conflict verification on that now. But I would like to submit this page 34.
To make a clarification, I don't know. Yeah, still ask the petitioner to make a clarification. They did not ask. Did you ask? I don't know.
For initially there was one for.
No. He's saying with regard to, I have made a statement here. The court has made a statement. Observation that the state respondents asked the petitioner to make a clarification with regard to the tax invoice dated 2010-2020. Is this correct?
But the clarification was not, but subsequently he filed on the presentation. That is.
So that is the clarification.
That has been
Not
discussed.
No, I don't know. I'll have to go through. These are facts.
I think technical argument, if Lordship has passed an order, Lordship took one understanding of your Lordship. He may not be agreeable to that order. But that may not be reason for review. That is not.
I'm not on that. I'm not on that part. I'm not on the merit. I'm on the fact. Whether the state had asked the petitioner to make a clarification. If you ask,
So far as this one, no.
but there was somewhere, I've read it. That's why I wouldn't have said it just like that. I read it somewhere in there. I'll have to go through again the entire thing. Such a thick. Huh?
Technical people after this on board. Technical report I have.
Yeah, what else? Besides that, what are the points?
Second.
Yeah.
I don't know the technical second outcome.
Huh?
Because of these, we still have the power to the security of this. And they will actually, if I was a student, they have not asked for.
Oh, there is somewhere. I won't have written it just like that. Yeah, I'll have to go through the entire now, so many documents again. I'll have to do. There's somewhere. There.
I think, I have to, because they have a right, they have a, just be right, education. Across the board. I was. I think that.
I think also out here there is para 22. I think out here it should read as the from the fourth line. If the tax invoice dated 2010-2024 was related to two air compressors, then it would not have been. Then it would not have been in relation to two air compressors. Then was very clear, it would have been in relation. It would have correct. You have to. It was correct. Then it would have been related to. fact, wait, 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 wait. After this, from the last, paragraph page 20, page 26. In fact, the last, in fact, what we have provided. Okay. Please come to, I think it's not reading the public. No, no, you see, I'm looking at page 9 of the evidence. Okay. Look at page 9. B, have you got B? Capital B. Start with in the, for that this honorable court when passing the aforesaid judgment dated, so in paragraph 22, it has been held that, correct? Yes. In fact, the tax invoice dated 2010-2024 line number 3 only speaks of one set of great corporation transitory amount. If the tax invoice dated, if the tax invoice dated 2010-24 was in relation to two A companies, comma, then it would have been relation to two different times. No, then it would. Where do you get this difference? From where did you use this word different? In the, when you say out here, that, in fact, the tax invoice, it starts here, in fact, the tax invoice dated 2010, 1, 2, 3, 4, 5. This 5. Where do you get this word different?
It's check this starting line number 3 of
I agree. No, I'm not on that. Right? It starts with from
line number 3.
line number
Of
3. Yes,
paragraph
yes, yes. Now I am coming here, line number 3.
Yes.
You go down, in fact, so 1, in fact, is first line, then number 2, number 3, number 4, and the first word in line 5, different. Where do you get this word different?
It did not have in relation to different types of air.
Where do you get this word different in the judgment and order? Where do you get this word different in the judgment and order?
Line number in the judgment paragraph 6th line. Page 26.
Yes, but how does, no, this is correct. It would not have been in relation, this is already there, just prior to that. Where have you got this word different? How do you have, where have you put it? You understand what I'm trying to say? In the judgment and order, that word different is not there in this sentence. Out here, when you have quoted it from the judgment, you have put this word different. 26, yes. Yes. Sixth line. Yes. No, no. This is correct. This difference is there. There are two different. You see, you see, when you come to this page 9 also of the thing, in their academic, come to that difference is here out here also in the next line. There are two different. One is in the 5th line and one is in the 6th line. You got? So out here in the order also, there this word different is there. Here in para 22 of the judgment order, in the 6th line, last word, different is there. But there is no word different
Yes, sir.
prior to this.
I got.
Why have you written this? This is wrong. You have purposely done it. We are trying to change the entire fact of the case. This is, what is this? What are you trying to play with? Trying to play with the court? Words that are not there in the judgment, you're putting it here. It has been purposely put. It has been purposely put. You see, it gives a different meaning to that sentence. What I have found out, but the particular cause of the setback is there. So nothing now, I'll have to see where you know. There has to be something. Anything else? What three? They're only two now.
One is that particular what, you want.
That I'll do. Look,
That is the second one of two figure two, that, for my. And third one of, what I say, madam, but considers, only that, they are not having air compression of the same trolley mounting. Of the cross, it's only air compressor two. So whether it is that one is trolley mounting or it is whether, factor mounting, it is a complete six. That is the.
I'll have to. I can't let this lying down. I'll let this happen. You cannot change the judgment of the court by putting in words that are not there. I can understand if you have not typed in particular word by mistake. But to add words that are not there, that cannot be allowed. Changing the context of the case.
But without the intention of other people.
No, this one is I'm just holding on. All right. Prime Minister. Do this thing. Also heard with the scene I have found it was one number one. The petitioner, the review petitioner, has paid for the review of the issued judgment and order dated 3/5/2020. Passed in WC 2068 of 2020. On three grounds. Firstly, there has been a mistake. Para 32. Where this court has held that there was no reason to intervene with two out of the three reasons given by the respondent for disqualifying the petitioner technical principle. In as much as this court in the said impugn judgment had already set aside two out of the three reasons for disqualifying the petitioner technical. As such, this court, as such, the instead of the word two in the second line of para 32, the word should be read as one. OWS, ONE one. Right. The second round of challenge, the second round of challenge made to the impugn judgment and order is that the state respondents never asked the petitioner to make a clarification with regard to the tax invoice dated 2010-2020. Thirdly, the petitioner had obtained a price breakup. Dated 16/5/2025 in relation to the tax invoice dated 20/10/2024. After the issuing judgment and order had been found. Which was to the effect that one air compressor was trolley mounted, while another air compressor was tractor mounted, which were bought by the petitioner at the rate of 35,001.3 lakhs. Next. The petitioner's counsel, the review petitioner's counsel, that the same, the said error being apparent on the face of the report and due to the breakup being provided by the seller of the air compressor, a review of the judgment order should be undertaken by them. Any citations you have to rely on? Okay. Mr. P. Nair, learned counsel for the respondent number 150, submits that what
The first, as regards this clarification, state respondent asked for the particular to make sure.
yes,
Even if this line is not in the make, what it will find in the description, what it will itself find on clarification.
page
121. So that clarification was there.
submits that he has got no submits that with regard to the stand of the review petitioner that no clarification was asked for by the state respondent. The petitioner in his representation dated 5/4/2025, which is at annexure I of the writ petition. A clarification had been made with regard to the tax invoice dated 20/10/2024.
But kindly say that clarification. You know how.
And this is clarification number one. Clarification number one. Yes. Yes, I think it.
So for a second point is concerned, Dr. has already observed that two different words are there in the.
That is not, he's not taken it, he has taken, but he has not mentioned. Okay, okay. Another. Fourthly, I think four grounds. No, third ground, I think this will be thirdly. That other two is, thirdly, that there was a no, thirdly will remain. That's not. I have heard the last possible. Yes, paragraph, just put right, then one part. While considering the submissions made by the counsel for the review petition, This court has noted that the review petitioner has quoted para 22 of the impugned judgment and order dated 15/25. With regard to the tax invoice dated 20/10/2024, which, according to the petition, proves that two air compressors have been bought on the basis of the net tax invoice dated 20/10/20. The para 22, the extract of para 22 which has been quoted by the petition in paragraph in ground B of the review petition is to the following. We take page 9 from here to I put it page 9. Yes, sir. The relevant extract of para 22, as provided in the judgment and order, in the impugned judgment and order passed by this court. States as follows. See, from at page 26, from here to I'll put this. Wait. A reading of the above clearly goes to show that the word different, that the word different has been used only once in the impugned judgment and order passed by the. However, in the quoted extract of the impugned judgment and order at para 20, at in ground B of the review petition, the word different have been used twice, thereby apparently changing the context of one sentence of the impugned judgment and order. Here, there is from the now by for long time I other the other day there was a issue in one of the courts with regard to a judgment passed by a judge. What was uploaded was different from the content of what was written. The online is different, and there are some differences. And in the judgment that he had signed in hard copy, there's it. Have to be very careful. Because it changes, you see, we cannot go through because I was just reading that there's something wrong here.
And the importantly, not, you cannot agree with the judgment after your. It would be a downfall. Can I keep them?
Okay, just write one more thing.
There is
Mr.
one-
P. Nayak further submit that just because the review petitioner does not agree with the views of the court as reflected in the impugned judgment and order, the same does not mean that a case of review can be made out only because of a difference of opinion. That's all.
So if you come to page 10, right?
Okay,
I think that. And accordingly, this honorable court accepted the finding of the state respondent that the appellant tax invoice dated 2010 to 2024 referred to only one air compressor trolley mount. The aforesaid finding is an error.
Para 10 of the
Page 10 of the
application.
ground B.
Page 10 of ground B, just like page 10 of ground B.
Here it is. The aforesaid finding is an error of the place of the record that after clause 4.1.8.1 provides neither two number nor two set. The said clause also does not of any particular type of air compressor with either tractor mounted or trolley mounted. Clause only states CFI 8 air compressor and the question of interpretation. Logic states one set cannot use, one set cannot. That is your logic interpretation.
See, whenever we buy a set, okay, it can mean two. A set of trousers or a pair of trousers does not, does a pair of trousers mean two? Now, if we say we buy a set of shoes, can it be mean, can it get, or a set of plates or a set of cards?
Same example, logic. If I buy one,
Supposing it is two, it will mean two identical or two similar types of items, not two different types of.
one trolley mounted, one tractor mounted. If I buy one.
And one is 135, 135,000, one is 1,30,000. And in the invoice, it has been shown as trolley mounted. The trolley mounted one costs 35. In fact, it should have been at least the tractor mounted, which was costlier, which should have been shown in the. But it was not shown.
But there is not very clear vision, but technically, we decided not to accept the second one.
And this is whether views can be substituted. Whether the views of the tender evaluation committee can be substituted by the views of this court or by the views of the tender. This could be.
It's very kind of disregard. Let's see.
Oh, no, I've been posting on this. After that, I was not doing anything. But I'm not accepting any evidence. No evidence. Now it's clear.